Hello everyone, I hope everyone's having a great last week of class. I'm excited to present to you today my final project. Today I'll be covering false advertising and federal statutes. So just to jumpstart with some key terms, some of these will be a review, some might be new, just depends on the cases we have covered. But the book covered trademark, but just as a reminder, a trademark is protection for words, names, or symbols of various different types that are associated with intellectual property. So, intellectual property, if you remember, is a piece of work of many different kinds that has resulted from one's creative mind. And these are different examples of trademark items. Like Tropicana, you can see the little symbol. Sometimes it's an R, which is reserved for certain types of protection, and then the TM, which stands for trademark as well. Okay, more key terms. A federal statute. So another one we have learned, but a federal statute is a law enacted by the Congress after being approved by the president. The Lanham Act is a federal statute, and it is a statute that governs trademarks. So it gives protection to the owner of a federally registered trademark item against similar ones that may confuse the common consumer. Then the FDCA, which stands for the Federal Food, Drug, Cosmetic Act, was enacted in 1938, and it gave rights to the Federal Food, Drug, and Cosmetic. It gave rights to the Federal Food, Drug, and Cosmetic Act to oversee the safety of food, drugs, and cosmetics. Yes, that is a federal statute. And then lastly, or two more, false advertising is the use or production of false facts or claims in order to promote product. So the promotion of false facts, basically. And then lastly is the preemption case. This is where one law preempts or supersedes another law that is present in a case. So one kind of overtakes the other one. Okay, so an introduction before we move into the case that I will be covering today. I am a strategic communication major with a digital media production minor. So a little background on why I chose this topic. So I'm hoping to find a career in advertising because I am very passionate about the psychology about why people buy products, what advertisements pull people in and really convince them to make that purchase. So the case that I'm about to cover involves false advertising, accusing a company of falsely advertising a product. So I'm very intrigued by the tactic that the company used to advertise the product, even though it was vaguely false. It wasn't very eminent that it was false, but research shows that it was false advertising. But I found it very interesting that the company went with that approach to advertising the product and the research that went behind it to show that people will be more likely to buy the product if it says this on the product. So I found that very interesting, so that is why I chose this. And now we will move into the case. So first, background on the players here. So the plaintiff is POM Wonderful, and POM Wonderful was launched in 2002, and it is owned by The Wonderful Company. And The Wonderful Company, just a brief statement about them, is a company that strives to provide various types of healthy products to consumers from various different brands. So they own POM and Fiji water and many different other ones that are all considered to be healthy products. That's how they brand themselves. Next is Coca-Cola, which many of you know. Coca-Cola, you might not know. You might know POM Wonderful as well, but I would hope that everyone knows Coca-Cola, maybe. But the Coca-Cola Company began franchised bottling operations here in the United States in 1899, so it's been around for a long time, and it takes pride in being the one of the best soda companies in the world, actually. Okay, so moving on into the actual case. So POM Wonderful versus Coca-Cola was a Supreme Court case, and it was decided in 2014. So POM Wonderful creates beverages mostly with utilizing pomegranate juice, and then Coca-Cola has many different branches of drinks, Minute Maid being one of them, and also they have Sprite and Diet Coke, etc. So Minute Maid is one of them, and they decided to make a pomegranate and blueberry mix blend in 2007. And so you can kind of see it's kind of small. I'll move my mouse around here. So it says pomegranate blueberry, and then it says flavored blend of 5 juices. So then you can see next to it, the tested contents are actually 99% apple and grape, 0.3% pomegranate, and 0.2 blueberry. So they put in bold pomegranate and blueberry. So they were very, they were promoting the pomegranate and blueberry because they had to have done research that shows that people will more likely to buy something that had pomegranate because maybe they were, backpack or, just kind of piggybacking, that's the word, off of Pom Wonderful and how people are interested in the health behind pomegranates. So Pom Wonderful sued Coca-Cola on behalf of the Lanham Act due to the fact that Coca-Cola was allegedly affecting the Pom Wonderful juice sales by presenting false advertising about the contents of the juice. So because there was only actually 0.3 and 0.2% of pomegranate and blueberry juice. But Coke argued that the FDCA, the FDA had approved their label and that therefore preempts the Lanham Act. So they think that that supersedes that. Therefore, their argument is invalid and the Lanham Act should not be applied in this case. So, and this is a link to a video of the case, just talking about, it's actually a humorous video, but I think it's funny. It's a recording of the actual judges talking from the case, but dogs are actually, it makes it look like dogs are actually saying it.
Saying, Justice Kennedy, I'm saying after the NLEA express preemption provision, a state cannot say that pomegranate blueberry flavored blend of 5 juices, which is perfectly consistent with the naming regulations as the U.S. agrees. Why is that? Because the naming regulations, Justice Sotomayor said, you can name your minority juice, your non-predominant juice, in either of 2 ways. You, the manufacturer, may either mention a percent.
You want us to write an opinion that said the Congress enacted a statutory scheme because it intended that no matter how misleading or how deceptive the label it is, if it passes the FDA, it cannot be. There can be no liability. That's what you want us to say.
We do not, Your Honor. We would want you to say that misleadingness, when it is defined by FDA in specific regulations pursuant to a specific statute that specifically seeks national uniformity in the sense that the manufacturer picks one label and doesn't, as the American Beverage Association brief says at page 7, create a logistical nightmare that you have to change your label in response to every jury verdict.
Let's suppose there were a consumer survey, as there was, and let's say it was a valid survey, and overwhelmingly consumers said that they are misled, that they thought that they were getting pure pomegranate, and they were just astonished to find that what they were getting was apple juice with what Mr. Waxman called a dropper of blueberry. Suppose the reality is that consumers are misled.
Okay, so that's just a little excerpt from the case. The disposition started in the district court, then there was an appeal, so then moved to the Court of Appeals, then the Supreme Court, and then we will see that the Supreme Court demanded a retrial. So again, the question is, does the FDCA federal statute preclude the Lanham Act? The decision made by the lower court is reversed, and the case is demanded a retrial under new terms, and those new terms are, we will look at the applied case, or the application of their decision, and you can see from the video that there was question as to if the FDA approved the label, the FDCA Act, protected the label, said it was approved, said it was safe. Does that mean that whether or not the common consumer is confused is irrelevant. So should the Lanham Act be applied here, or should it not, just because the FCDA Act was applied? And then the findings. So the application. The case involves two federal statutes and is therefore not a preemption case. So both statutes are similar enough, and they should both stand and be applied together. But they should be applied in full, since they are not irreconcilable. Like I said, the statutes complement one another and should be applied as to not, quote, and ignore the distinct functional aspects, unquote. There's no clear evidence to support the idea of the statutes not being able to be applied at the same time, and it is clear that this lawsuit is not undermining the FDA regulations and its authority. So, like referring back to the argument, it is not undermining the FDA's approval of the label by applying the Lanham Act. So there was nothing wrong or controversial about that. So, going back to the decision made by the lower court is reversed. So the case is made under a retrial under the terms that both statutes should be applied. It was an invalid argument for Koch to say that the FDCA precludes the Lanham Act, so both should be applied. And the significance of the case. This was a huge event that happened because it set precedent for future cases, saying that federal statutes that are similar should stand together and not preclude each other. So one should not supersede the other. So regulations made by the FDA will not preclude other acts. So the Lanham Act will be applied to brands that produce false advertisements. So it set precedent for many cases to come. So it was a very, very significant case. And then personal takeaways from me. False advertising is, I think, committed very often, and that's just from observation. I think it is important to keep in mind that that is a tactic that many companies often take, and I think it would be beneficial for me once I'm in a company to be on the lookout for that, if other companies are trying to take advantage of that, and if it is affecting my sales or the company sales that the theoretical company that I work for, if it's affecting their sales, I can be on the lookout, and I would be, protected by the Lanham Act if I'm working for a trademark brand. So I think that is very important to keep in mind, the importance of trademark if it is something that needs to be protected, and of importance, and if if it should not be used by other companies as well. So I think that is, it's very interesting and is something I can, to keep in mind, and to make sure that I also don't commit false advertising because, as a StratCom major, I, know it is very important for consumers to be educated and to be, transparent so they know that they are getting exactly what they want. So I think this case is very important and it's also very recent. So it has been, set precedent for most recent cases. Then here's my works cited. So thank you. I want to thank everybody for listening to all my presentations this semester. I would love to get your feedback on my presentation skills. I went a different route than I have the past two. Similar to my first one, I didn't do video. I didn't show my face this time. And I would like to know your opinion, which one is more effective, I would say. And also, the effectiveness of my presentation style, how my presentation looked, and how impactful it was for you. I'd love to get your feedback on that, and also your thoughts on false advertising. If you've had any personal experiences of that, maybe you tried a product based on and chose it because of what you saw on the label, and then what you got, you really found that it was not what they had advertised. So I'd love to hear, stories about that. And thanks again for watching till the end. I hope you have a great day and good luck on your final projects.